All right, I'm Stephen Thrasher, a staff writer at the Village Voice, and I'm here with Metro Weekly's Chris Geidner. It's February 7th, a big decision out of the Ninth Circuit Court of Appeals today out of San Francisco. And Chris, explain to us what exactly this ruling means today.
Well, the Ninth Circuit decided today that the trial decision from August 2010 by Judge Von Walker was correct, that Proposition 8 is unconstitutional. However, the judges, it was a 2-to-1 decision, and Judge Stephen Reinhart wrote for the two-judge majority that he based his decision on a more narrow interpretation of the law than Judge Walker had done, based on an earlier Supreme Court case, Romer versus Evans, that was out of Colorado, that related to an anti-gay amendment similar to Proposition 8, as Reinhart wrote today, that was taking away pre-existing rights for LGBT people.
And it's also worth noting, I think, that even though the decision was 2-to-1 on the constitutionality, it was unanimous, right, that Judge Walker could rule on this case as a gay judge.
Yeah, it was unanimous as to the fact that the claim that nobody, I don't think, perhaps even the proponents thought, which was that because Judge Walker had is gay and had a same-sex partner to whom he wasn't married, that he had an interest in the case and should have to recuse himself. That was never taken seriously by anybody.
Anybody but Nom, perhaps.
Well, yeah, I don't even know if they did. I think was a very convenient fundraising ploy to make that more of an issue. But I don't think any legal scholars, even conservative ones, really took that claim seriously.
Well, the first question I had today was, what does this mean for same-sex couples in California who want to get married? When could they conceivably get married?
Well, today, nothing. The court did keep its existing stay in place for the time being, so there can be no marriages for now until a mandate is issued, which will come if the proponents choose not to take action to appeal. So that
which is not likely.
Right, which is unlikely. So the odds are that there will be a stay pending appeal, similar to the stay pending appeal that the Ninth Circuit issued when they took this case. The only real question is whether or not the proponents are going to seek further review in the Ninth Circuit, something called en banc review, which is the full scope of the judges who sit on that court, or whether they will go directly to the Supreme Court. So that's the thing that we're really waiting to find out from the proponents.
Well, given your experience looking at this case in great detail over the past couple of years, what do you think is the most likely path forward for the case as it goes up the judicial ladder and potentially to the Supreme Court?
I think that University of California Irvine law professor Rick Hazen already wrote about one of these issues, this en banc versus Supreme Court review, and he said, and I concluded, and I think correctly, that it's more likely that the proponents are going to go straight to the Supreme Court, because the Ninth Circuit is a mixed bag at best for them, and they know that this case is eventually going to go to the Supreme Court if they keep losing, and so why not give it more importance right now before the presidential election, before a potentially conservative justice leaves the bench and a more liberal justice takes over, and get this case there as quickly as possible.
Do you have any insight into, I'm forgetting high school civics here, if the case were to go to the Supreme Court, how does the court itself decide it? Is that the full 9 members of the court decide?
Yeah, it's the 9, well, I mean, the first thing that happens at the court is that you have to ask if they'll hear the case,
You think not,
and
and you're thinking the proponents of Prop 8 will ask for that, most likely.
well, yeah, I mean, if they keep losing, if they either go directly or if they go en banc and lose again, they will ask the court for review, and if they do, four of the justices need to agree to hear the case in order for the court to hear it.
Okay. And lastly, go a little bit more into what the scope of this decision means. You said it was narrower than Judge Walker's had been. What could this potentially mean for same-sex marriage? As I understand it, would mean obviously nothing in New York State here where we now have it, or in the District of Columbia perhaps where you do as well. But what would it mean in Washington State where there is a pending...
Well, yeah, it's actually really interesting, and Washington State is probably one of the areas where it could most quickly become relevant. Is that this Romer-based decision, which basically says that you can't take away an existing right of people based on animus, and that was the case decided in Colorado's Amendment 2, which basically eliminated the ability to create non-discrimination measures based on sexual orientation, and what the Ninth Circuit said today applied to Proposition 8. What that could mean in other cases is that while this was a situation where there were already marriages happening, and that was pulled back, and that's what is particularly egregious here, it's very easy to see how advocates pushing for marriage equality would argue, even if, let's say, Washington State does pass marriage equality legislatively, and then there's a referendum. If the referendum fails, it's very easy to see how advocates would argue that the same logic applies, that the state legislature had decided, the governor had signed this bill, and it was only animus that led voters to repeal it. And then if you get a ruling like that, then you could make the same logic for states that have passed anti-gay marriage amendments in the past without even having passed affirmative legislation. And so it would be a course of expanding the logic behind today's ruling over time to include more and more states.
So is that the kind of thing, as Olson today was speaking at the press conference about how important it was that you have this this judicial record, and for example, if the Washington State referendum went before a district court, could they then point to this as an appeals court level decision upon which they can base their...
This is the Ninth Circuit Court of Appeals. This is the level below the Supreme Court. It applies, I mean, specifically with Washington, it is binding precedent because Washington is within the Ninth Circuit. So this is the law today in Washington State. So Washington State is actually sort of the ideal state to be thinking about when you're thinking about this ruling. Outside of Washington, outside of the Ninth Circuit, if this, let's say Maine, where you did have a referendum that was successful in overturning a legislative marriage equality bill, the argument there would be persuasive authority is what it's called, but not precedential authority. So it's something the court would look at and say, well, that's what our fellow judges have decided. We will give it its due consideration, but we can decide something different if we interpret Supreme Court precedent differently.
All right. Well, thank you so much for helping us untangle this. A very exciting day. I'm off to the Stonewall Inn to go cover a celebration rally that's happening. Thanks a lot, Chris.
Bye-bye.
Bye-bye.